Hello and welcome to the Minimum Competence episode for Thursday, August 13th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, a plaintiff's firm could pocket $67 million from New Mexico's Meta verdict. Trump media is sued over a service selling early access to the president's posts, and Palestinian students sue Colombia over alleged bias. Let's remember, the real question of capital punishment isn't whether people deserve to die for the crimes they commit, but whether we deserve to kill. And read today's legal news. On this day in legal history, August 13th, 1964, two men, Peter Anthony Allen and Gwynne Owen Evans, were hanged simultaneously in two different English prisons for the murder of a man during a robbery. They were the last people ever executed in the United Kingdom. Evans died at Strangeways Prison in Manchester and Allen at Walton Prison in Liverpool, both at 8 in the morning, and with them, centuries of capital punishment in Britain came quietly to an end. Neither man knew he was making history. The abolition of the death penalty wasn't yet law, but the machinery of change was already turning. The very next year, in 1965, Parliament passed the Murder Act, which suspended the death penalty for murder for a trial period of 5 years. In 1969, Parliament made that suspension permanent for England, Scotland, and Wales. The death penalty lingered on the books for a handful of exotic offenses, treason, piracy with violence, certain military crimes, until it was finally abolished completely in 1998, bringing British law into line with the European Convention on Human Rights. The significance of August 13th in 1964 is sharpened by contrast. Britain reached the end of capital punishment through ordinary legislation, as much of Europe followed a similar path, treating abolition as a basic human rights commitment. The United States took the opposite fork. The Supreme Court briefly halted the death penalty in 1972 in Furman v. Georgia, only to allow it back 4 years later in Gregg v. Georgia. And capital punishment remains part of American law today, administered by the federal government and a number of states. So this anniversary is a useful mirror, a reminder that two closely related legal systems working from a shared common law inheritance reached opposite conclusions on one of the deepest questions a legal system can face: whether the state should ever have the power to take a life. That's the question our opening quote from Brian Stevenson puts squarely on the table. The law firm Motley is in line for a payday of more than $67 million, its fee for winning New Mexico's sprawling case against Meta. We covered the underlying result. A judge ordered Meta to pay $567 million into a teen mental health fund, on top of $375 million in civil penalties a jury imposed in March, bringing New Mexico's potential recovery to more than $942 million. Motley represented the state on contingency, and under its contract, it can seek a sliding scale cut: 20% of the first $50 million recovered, scaling down to 5% on amounts over $250 million, which works out to roughly 7% of the total, or about $67 million. Here's the practice of law angle worth understanding. States increasingly hire private plaintiffs' firms to bring these massive cases because they don't have the in-house firepower to go toe-to-toe with a company like Meta and its armies of lawyers. The firm fronts the enormous cost and risks of years of litigation in exchange for a percentage if it wins, the same model that produced the giant tobacco settlements of the 1990s, in which Motley was a central player. Supporters say it lets under-resourced states take on deep-pocketed defendants they otherwise couldn't touch. Critics say it hands public law enforcement power to private firms with a profit motive. The significance is that this is the economic engine behind the whole wave of state social media litigation we've been tracking. The fee comes out of New Mexico's recovery, and it only gets paid after appeals conclude. And Meta has said it will appeal, so the number, like the verdict, isn't final. But it's a rare, concrete look at the money that makes this kind of public interest litigation actually happen. Two press freedom organizations, The Intercept and the Freedom of the Press Foundation, have sued in Manhattan federal court to shut down a Trump media service that sells wealthy subscribers early access to President Trump's social media posts. The service, called Truth API, launched August 1st and charges up to $100,000 a month for a faster feed of 10 high-profile Truth Social accounts, including the president's own. The legal concern at the heart of the suit is a specific and serious one. Trump's borderline incoherent posts routinely move financial markets. An announcement about tariffs or a company can send stocks lurching. And a paid feed that delivers those posts to deep-pocketed subscribers before the general public gives those subscribers a head start to trade on market-moving information. In other words, it potentially creates a two-tiered market in the president's words, where those who can pay six figures a month get to act on the presidential statements seconds or minutes before everyone else. That's the kind of information asymmetry securities law generally frowns on. The service drew scrutiny fast. Senators Elizabeth Warren and Adam Schiff had already called for a government investigation days before this suit. It's also legally novel. The plaintiffs are press freedom groups framing public access to a president's official-ish communications as a matter of public interest, which raises interesting questions about their theory and standing. The significance is that this sits at a genuinely new intersection of a president who governs partly through market-moving social media screeds, the business incentive to monetize that, and a securities and public information framework that never contemplated selling early access to the president's feed. However the case comes out, it's a preview of the strange legal questions created when official speech becomes a paid product. A group of current and former Palestinian students and staff have sued Columbia University, alleging that the school discriminated against its Palestinian community over the past 2 years. According to the complaint filed in New York, the plaintiffs say Columbia failed to protect Palestinian members from harassment, subjected them to what they call unfair and biased disciplinary hearings, and actively participated in and amplified what they describe as racially, ethnically, and politically motivated targeting of Palestinians on campus. The legal vehicle here is worth understanding because it's the same one being wielded on multiple sides of the campus fights. Civil rights law, principally Title VI of the Civil Rights Act, bars institutions that receive federal funding from discriminating on the basis of race, color, or national origin. We've seen Title VI invoked against universities over allegations of anti-Semitism, and we've seen the Justice Department use it to pressure schools like Harvard. Here, Palestinian and Arab plaintiffs are invoking that same framework to allege discrimination against them. The context matters. Columbia suspended more than 65 students last year over a pro-Palestinian protest that shut down its main library, and it agreed to pay the federal government over $200 million to resolve federal probes and restore funding. Columbia has denied discriminating and says it condemns hate, and it declined to comment on the pending litigation to Reuters and other outlets. To be clear, these are allegations in a complaint, not proven facts, and I'm not weighing in on the underlying political conflict. The significance is legal and institutional here. Universities are now being sued from opposite directions under the very same civil rights statute, and Columbia in particular finds itself squeezed between federal enforcers, one set of students and another, each claiming the protection of Title VI. It's a vivid illustration of how anti-discrimination law becomes the battleground when a campus fractures. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and click a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, there may be times when we are powerless to prevent injustice, but there must never be a time when we fail to protest.